Today in this video, I want to talk to you about how to avoid a conviction being recorded against your name for a drink or drug driving offence in Queensland. So in Queensland, usually if you go to court for a drink or drug driving offence, it is likely that the court will record a conviction against your name for this particular offence. However, under Section 12 of the Penalties and Sentences Act 1992, this particular section of the Act does offer the court a discretionary power whether or not to record a conviction for a particular criminal offence in Queensland. In relation to drink or drug driving matters, or other serious traffic matters or offences before the court, there are a number of issues that the court will take into account in deciding whether not to record a conviction against an offender's name. So some of the primary or most important issues that the court will first consider is the nature of the offence. So how serious the particular offence is. So for example, for a drink driving offence, how high the blood alcohol reading is. The higher the reading, the harder it will be to obtain a no conviction recorded against your name. So that's one particular issue. If there's any other significant aggravating factors involved in your particular offence, such as a vehicle crash, injury to other people, the number of people that have been put at risk, your manner of driving, a whole range of factors which will be dealt with on a case-by-case basis will be taken into account in relation to the nature of the offence, or what they call the objective seriousness of the offence. So the more serious the offence is, the harder it will be to persuade the court to not record a conviction against your name. The other issues which the court will certainly have regard to is the character of the offender. So if a person has previously got convictions for criminal or serious traffic offences against their name, well, this will be a major consideration that the court will take into account in dealing with them under Section 12 of the Penalties and Sentences Act, which gives them the power to record a conviction or not against a person. So if a person's got a terrible traffic record and it is a drink or drug driving matter, and they've got prior offences of a similar nature, even if they haven't received convictions in the past, then it will show the court that there is a pattern of reoffending, and it will come to a point where the court will just say, listen, your character's not good enough to warrant the court not recording a conviction against your name. So a person's character is something that will certainly come into play when the court considers this particular issue. A person's age will also come into effect. So if you've got a young offender who has a whole lifetime ahead of them and prospects of and aspirations of a career or future employment where a conviction could affect them going forward in the future, that will be taken into account in relation to this particular matter. So then following on from that, the nature of the offence, the person's character and age, the court will also consider other issues surrounding how a conviction could impact a person's economic or social well-being at the present time, or their future prospects of employment going forward into the future. So a lot of that comes down to your lawyer to be able to ask those questions and to prepare a case to present to the court to try and persuade the court how a conviction could impact the offender. Certainly, the first issues we looked at surrounding the nature of the offence, the objective seriousness of it, the person's character and age, these are issues which are not really in our control to manipulate or change or persuade the court on. Certainly, we can try and persuade the court that these particular issues do warrant a person to be considered for a no conviction, But more importantly, the issues that we do have more control on is being able to obtain evidence to prove to the court how a conviction being recorded would impact a person's ability to earn an income, either now or into the future, or the person's social well-being, whether a recording of a conviction could bring upon significant hardship upon the person. What we usually do is try and obtain references, employment contracts, any other sort of documentation or evidence that would provide the court with the information and evidence to show that a recording of a conviction is considered a detriment to them. So in certain industries, there is mandatory criminal background checks. Professional industries such as finance, banking, the legal industry, medical industry, accounting, a lot of professional industries do have a regulatory body in place to do character tests upon people before they're employed or registered within those industries, and they will require mandatory criminal background checks to be conducted, and certainly a recording of a conviction could certainly affect a person's prospects of employment. Other industries such as trade industries, construction, many other industries that do source out contracts, government contracts. I do know that governments are reluctant to hand out contracts and have employees involved in those projects or contracts if they have got criminal convictions recorded on their history. So these are all issues of evidence that we need to bring up, collate together, present to the court to show the court that the recording of a conviction could have significant impacts on a person's ability to earn an income or their social well-being now or into the future. So these are certainly questions that we need to ask, evidence that we need to prepare and present it to the court in relation to asking and requesting and persuading the court to deal with this matter or your matter under a Section 12 of the Penalties and Sentences Act, which, as I've mentioned earlier, does give the court the discretion to or not to record a conviction against a person's name. As mentioned, all these matters are dealt with on a case-by-case basis, and you may have some more questions, so feel free to contact us on 1300 941 900, or alternatively go along to our website, which is boormanlawyers.com.au. There's a raft of information there which may better inform you on these particular issues.
I want to thank you for tuning into Boorman Lawyers today. You can catch us at any of the usual social media platforms. Please subscribe to our YouTube channel. And if you've got any questions or queries, please don't hesitate to contact us on 1300 941 900.
Hey guys, thanks for tuning into this video today. I really hope it was informative and helpful for you. There's another couple of videos below that you might want to check out that may be very useful for the process that you might be going through at the moment. Please feel free to like, follow, share, and subscribe to our YouTube channel because we've always got fresh new content coming through all the time.